Monsieur le Sénateur Boisvenu, suivi de Sénateur Carignan.
Senator Boisvenu, please go ahead. Thank you, Chair. Welcome, Mr. Blair, to our committee. Earlier, I was listening to Minister Fournier, who told us that he was very concerned by domestic cultivation of cannabis, and that's one of the reasons why Quebec is prohibiting it, because he fears that market is will be an opportunity to create an irregular market. I'm not going to say illegal, I'm going to say irregular, because that's what your government used. So he fears that it will create an irregular market, and it's the kind of cultivation that will be impossible to police or to monitor. Chief Harel said that, and so did the minister. It will be impossible, really, to monitor. And also it is a production that means that there will be a certain captive market. So this bill maintains the cultivation of 4 plants. Doesn't that foster a type of a sort of gray zone or a parallel market that could have consequences on the so-called legal market?
I want to be very clear. There is no market available in these regulations. We have, and I actually work very closely with the task force where this issue of personal cultivation was extensively canvassed on that committee. There was a belief in many jurisdictions that we spoke to that personal cultivation would allow individuals who perhaps couldn't afford to participate in the regular market because of the cost, to allow them to have access, which the courts have said is reasonable. But any sale of that, like when you use the term market, I might suggest that market is an absolute prohibition. It is a serious criminal offense to sell any amount of cannabis produced outside of the licensed regime. And so if an individual was to grow for personal cultivation an amount of cannabis up to a limit of 4 plants, and the determination of 4 plants was based on, quite frankly, 4 plants was considered reasonable based on our experience in other jurisdictions and also under the medical regime for an amount of cultivation which is suitable for personal use. But any effort to market that, to sell that, constitutes a serious criminal offense under this law. And so that remains in effect, that it cannot be sold. And we've said any amount of cultivation above 4 plants will be an offense under Bill C-45, and any effort to sell it or even an intent to sell it would constitute...
Don't
you agree with Minister Fournier that it will create a parallel market and that production will be impossible to monitor by Canadian police forces?
No, with great respect, I do not. I will tell you that I have dealt with that criminal market for decades. And it wasn't 4 plants that we encountered when we went into these residences that were given over to cannabis cultivation. It was 400, and in some cases 4,000 plants. And the houses had been converted to the sole purpose of growing cannabis, and it was a commercial operation. That activity remains a serious criminal offense. But 4 plants, quite frankly, and I take the law enforcement's point about the difficulty of enforcing 4 plants. It is precisely the same difficulty, I might suggest, to enforce 0 plants. You still have the difficulty of not being able to get into the house without reasonable probable grounds and the benefit of a search warrant. And so the threshold, and I think that is very clear in this legislation, the threshold of what constitutes an offense is more than 4 plants in cultivation, and what becomes a serious criminal offense is either the intent to traffic or the actual trafficking of that drug. And quite frankly, the law enforcement has all the tools that they need for investigation, but also in the laying of charges and the prosecuting of those offenses, because growing that for the purpose of sale or for actually selling it remains a serious criminal offense within this legislation.